Hello, my name is Michael Wingate Hernandez, and I'm talking to you from the offices of Commonwealth Life and Legacy Counsel, PLLC. This is an estate planning firm in Troy, Virginia. I think my wife, who is also an attorney and a principal in the firm, would like me to say that Troy, Virginia and Zion Crossroads is pretty much the same place. I'm coming to you today to talk a little bit more about powers of attorney in Virginia. You may recall that last week we talked a little bit about the validity of powers of attorney in the Commonwealth, and I'll put a link to that previous video in the description below. Today I'm going to answer a few more questions that we get here at Commonwealth Life and Legacy Counsel. Like, for example, does my power of attorney have to be an original? Does my power of attorney have an automatic expiration date? Or how do I revoke previous powers of attorney that I have made? And then finally, how does a power of attorney actually terminate? Getting right into the questions, I'll say that in Virginia since 2010, a photocopy or even an electronic copy of a power of attorney is as good as the original. So don't be concerned if you don't have an original of your valid power of attorney. The copy should work just fine. Secondly, powers of attorney in Virginia don't expire by the passage of time. And it doesn't really matter how old they are. They're valid unless they've terminated by some other means. One of the means for termination, as the previous question about revocation suggests, is for a power of attorney to be revoked. And usually the question is, do I have to revoke previous power of attorneys that I've made in my current one, or does it happen automatically? And the answer is, it's not automatic, which means that if you don't revoke previous powers of attorney explicitly in the power of attorney that you're making now, then those survive and will continue to be effective until they've been revoked or they otherwise terminate. Finally, talking about the actual termination or the events that result in the termination of the power of attorney is a little bit more complicated, but I'll hit the high points for you. Powers of attorney typically terminate. Well, they certainly terminate by the death of the principal. You remember we talked last week about the fact that there are these two parties to a power of attorney, actually three ultimately, if you include the third party that is in a position to recognize the effectiveness of the power of attorney. But you have the principal who needs something done, and you have the agent who's the person who is going to do that thing on behalf of the principal and exercise the authority that the principal gives under the power of attorney. Well, a power of attorney terminates naturally by the death of one or both of those individuals. If the principal dies, the power of attorney terminates. If the agent dies, of course, his agency terminates as well. Also, you can revoke, or the power of attorney can be terminated by revocation. Typically, in a power of attorney that we would draw in this office, there would be a statement that indicates that the power of attorney that's being executed currently revokes all prior powers of attorney, unless there are some powers of attorney that we want to specifically survive, in which case we would make an exception for those. A power of attorney can also terminate by its own terms. In other words, the power of attorney can simply say within the document, for example, explicitly that it's not a durable power of attorney, in which case that power of attorney would terminate upon the incapacity of the principal. You may recall that I stated in the last video that in Virginia, a power of attorney that's executed now and any time since 2010 is automatically durable unless by its own terms it states that it's not. Another term that could cause a power of attorney to terminate is a term that simply indicates that the power of attorney only lasts until a certain time or has a date of termination within it. Powers of attorney can also terminate when their objectives are accomplished. For example, if a power of attorney is a special power of attorney that's designed to authorize the agent only to do a specific thing, like, say, purchase or perhaps sell a piece of real estate, then by the terms of the power of attorney, it would state, or should state, that the power of attorney terminates when that event is accomplished. But even if it doesn't, then if it's clear what the purpose of the power of attorney is, and that purpose is accomplished, then the power of attorney, by its own terms, would come to an end. Finally, and the only other termination event that I'll talk about in this video is divorce. In Virginia, if the agent of the principal is the principal's spouse, then divorce or proceedings consistent with divorce would operate to terminate the power of attorney. And that includes, of course, filing for divorce, filing for separate maintenance, or filing an action for child support of a child that is in common between the agent and the principal. We find these questions about powers of attorney to be very interesting here at Commonwealth Life and Legacy Counsel, PLLC, and we hope that this video message and these few answers that we've given today about powers of attorney have been interesting and perhaps useful to you. And if they have been, then we encourage you to subscribe to our videos and to indicate that you like the video if you do in the comments below. Thanks.